And this is Chris Haley. On today's video podcast. I wanted to discuss the judging of qualifications of members of the California Legislature. In the state constitution in Article 4, Section 5A1, it specifies that each house of the legislature shall judge the qualifications and elections of its members, and by roll call vote entered in the journal, 2/3 of the membership concurring, they may expel a member. And the courts in this state have determined how far that judgment actually goes. The legislature also has constitutional power to suspend members. This is found in Article 4 in Section 5A2, Cap A, where it says each house may suspend a member by motion or resolution, adopted by roll call vote entered in the journal, 2/3 of the membership concurring. The motion or resolution shall contain findings and declarations setting forth the basis for the suspension. This section of the state constitution also allows the legislature to deem the salary and benefits of a member to be forfeited for all or part of a period of their suspension. And a suspended legislator cannot exercise any of the rights, privileges, duties, or powers of that office, or utilize any resources of the legislature during the time that their suspension is in effect. Now, the California courts have been clear in deferring to the legislature on the question of who judges the qualifications of a member, and the courts in this state have given full respect to the explicit language found in Article 4 of the state constitution. So as a result, challenges to whether a member is entitled to take his or her seat in the California legislature, or whether he or she can remain in office, are rarely considered by the courts. One of the most famous cases was between then Assembly members Gil Ferguson and Tom Hayden. So under Article 4, Section 5, the legislature has sole jurisdiction to determine the qualifications of its members and the sole right to expel them from membership. Accordingly, an action by a veterans group to disqualify an assembly member, Tom Hayden, from holding office because of his alleged support of North Vietnam against the United States during the Vietnam War in reliance upon Article 7 of the California Constitution, which provides that no person who advocates the support of a foreign government against the United States in the event of hostilities shall hold any office or employment under the statute. Nonetheless, in this case, the trial court had properly dismissed the complaint after sustaining the defendant's demur without leave to amend. And what the appellate court said was that under the same constitutional principle of separation of powers, the plaintiffs, including then Assemblyman Gil Ferguson, were foreclosed from attempts to prohibit the Attorney General or the Secretary of State or even the County Registrar of Voters from certifying the election results, as well as the swearing in or the disbursement of money to then Assemblyman Hayden, or to interfere in the legislature's determination of his qualifications or fitness. And this was decided in California War Veterans for Justice versus Hayden, a 1986 California appellate court decision. Similarly, a state appeals court ruled that the judicial branch lacked jurisdiction to judge qualifications to serve as a senator for the 14th Senate District, again pointing to Article 4, Section 5A, in which the court said the state Senate was vested in being the sole authority to judge qualifications. It said that the California Constitution vests in each house of the legislature the sole authority to judge the qualifications and elections of a candidate for membership in that house, even when the challenge to the candidate's qualifications is brought prior to the primary election. This was the appellate court decision in 2012 in the case of Fuller versus Bowen. Now, more than 100 years ago, the California Supreme Court ruled that the power conferred upon the Senate by the Constitution to determine the rule of its proceedings and to expel a member is exclusive to it. And the judiciary has no power to revise even the most arbitrary and unfair action of the legislative department. There's no constitutional provision giving persons who have been expelled the right to have a trial and opportunity to be heard in the Senate, other than that which that individual had received. And this was the decision in French versus Senate of California by the California Supreme Court in 1905. So, as you've heard, the state courts in California have deferred entirely to the legislature based upon a clear reading of the state constitution and the exclusive power of the legislative branch of our state government to determine properly the qualifications of the members of the California state legislature.